And what do you do for a living, ma'am?
I am an attorney full-time. I represent contractors, primarily people that work in the construction business.
And you're a partner at the firm Hensley Benitez Law, is that correct?
I am a partner at the firm Hensley Benitez Law.
What was your role with regard to this case?
I was the attorney primarily responsible for the case. I oversaw all of the work that was performed on the case. I prepared the petition originally. Well, maybe I didn't prepare the petition. I reviewed all the petitions and basically was the liaison with the client for information and have seen it through to today.
What geographic region in Texas do you normally practice?
Most of our clientele is in North Texas. However, we have clients throughout Texas.
What percentage of the firm's cases are cases similar to what we're talking about today, construction cases?
Well, probably 90% of our cases are construction cases. As pertains to the type of case we're here about today, probably 80%.
So are you familiar with the fair, customary, and reasonable rates for attorneys performing the type of work required for this case in the Dallas area?
I am.
And what are the rates that were charged on this case?
$350 an hour for partners, $300 an hour for associates, and $100 an hour for paralegals.
So what is the amount of attorney's fees that we're asking for the plaintiff in this case?
Total legal fees through the time of trial is $15,895.
Now, is that strictly attorney's fees, or does that count any fees or costs?
No, there's in addition to the $15,895, there is $750 for mediation fee and $1,440.17 of fees, $750 of which is for mediation.
So do you believe that amount that you just testified to be a very reasonable amount of attorney's fees?
I do.
And what did you consider in reaching that opinion?
I reviewed the documents in the case. I reviewed the pleadings of the case, the time that the case has been on file, the work that was done prior to filing suit, and basically the type of work that it was. And I believe that based on all of that, $1,500,895 is a reasonable price to take a case of this complexity to trial as a plaintiff.
So I need to stop you there. You said 1,500. Is that what your testimony is?
$15,895.
Of that amount, can you explain to the court what percentage of work and the nature of work was done by partners as compared to associates?
Yes, a little 29.3 hours of partner time was spent on the file, 16.4 hours of associate time, 7.2 hours of paralegal time.
Are there any other factors that you considered when determining whether that fee was necessary or reasonable?
Well, it's, had we not been working on behalf of 911, we certainly would have been working on behalf of another client, providing the same kinds of services.
Have you reviewed the fee sheets for this case in preparation for your testimony?
I have.
Have they been produced in this case?
All but the work from last night and today, yes.
And what exhibit are they labeled as in the litigation?
36.
Judge, we move to enter exhibit 36.
The objection to exhibit 36.
No objection.
Exhibit 36 is admitted.
Did you assess the time and labor that were required to accomplish the tasks in this case?
I did.
Did you conclude that? What were your conclusions?
Well, As appropriate as the case went along, we certainly made adjustments if we felt like there was any time that was excessive. But I am, among other things, responsible for reviewing all invoices prior to them being sent out to a client. And I believe that the time that has been spent on the activities identified in the invoices are reasonable. They would needed to be performed and they are being reasonably charged.
Were you responsible for assigning discrete tasks as well on the case to different lawyers?
Yes.
Did you explain to the court what here you took to make sure that, to determine who got what?
Well, certainly try to match the work to be performed to the skill level that's required to perform it, and taking into account sometimes that a more skilled or more seasoned lawyer can do something as quickly or quicker than a not as skilled lawyer, even though it's billed at a higher rate.
Did you give any consideration to the timing relative to the case in which these services were performed?
Yes,
And what were your conclusions based on that analysis?
that the work that was performed was timely performed. It was necessary to be performed to move the case forward to protect our client's interest.
And then after the work was performed, did you take any steps? I know you said you're responsible for the bills going out, but did you take any specific steps with regard to the reasonability of the number of hours to accomplish the tasks that you assigned in this case?
Yes, part of reviewing the invoicing is to review the task that's being performed and the amount of time that was spent performing it.
Have you considered the appropriateness of any appellate fees in this case?
I have.
So in the event that this case is appealed by the other side, via mandamus or via, let's start with via mandamus, what would be a reasonable amount of attorney's fees to ask the court to award to push back against an unsuccessful mandamus?
I believe $8,000 is a reasonable amount.
And in the event this decision is found in favor of plaintiff and then it is subsequently appealed to an appeals court, what's a reasonable amount of contingent attorney's fees?
I believe that $15,000 is a reasonable fee.
So, and is that answer conditioned on the outcome of the appeal? And if so, please explain that.
Well, if we're not successful with the, sustaining the judgment, then I would not expect to be awarded fees.
In the event this case is subject to a writ of certiorari to the Supreme Court, which is unsuccessful, what would be a reasonable amount of attorney's fees?
$18,000.
And in the event this case goes to the Texas Supreme Court and the defendant is unsuccessful with that appeal to the Supreme Court, what is a reasonable amount of fees that we would incur?
I believe that $28,000 would be reasonable, conservatively.
If plaintiff is successful in its case today and is awarded some amount of damages, and those damages are not paid within 30 days, what is a reasonable attorney's fee, if any, for collection of that debt?
It is impossible to try to set a fee for that because there's no way to know how much time and effort is going to be expended in successfully collecting that amount of money. I would simply ask the court to award reasonable fees incurred in recovery of the debt.
And those reasonable fees would be at the hourly rates you mentioned before, or would there be a different rate for that kind of collection?
We had the hourly rates mentioned before.
We'll pass the witness, Judge.
Any cross?
Yes, Ms. Hensley. Well, let me start off with the good things. Is Baylor Law School, is that a good law school?
I think it's a good law school.
Where'd you get your JD?
At Baylor.
Okay. And did you, how long have you been in the construction field in your primarily focus of your, as the primary focus of your practice?
I've been exclusively focused on construction since 2005.
Oh, prior to becoming a lawyer? I'm sorry, what year did you graduate from law school?
2004?
Oh, okay, sorry. And did you, your client has attributed you to the authorship of this contract, which is Exhibit 5, and I read on the back of it, the fine print. Did you get that from other forms, or did you sit down and write this form?
Objection relevance.
It's a contract in issue, Judge, and the client said that she wrote it.
Overruled.
So I did not write the contract.
I'm sorry, you overruled my objection, Judge. I'm sorry.
Yes.
All right, we're just checking my witness. I don't want her to go too far.
Okay, Judge, I think Miss Inslee is doing fine. I don't think she needs Mr.
See that?
Brian to coach her.
I have written several contracts for 911. This is not one of them.
Okay. Knowing what you know now, would you have added something specific about lost profits?
No.
Okay, objection irrelevant.
Yeah, sustained.
Okay. Would you agree it doesn't, I believe you've represented, but you weren't under oath. You're under oath now. First off, you're an officer of the court. I forgot, were you sworn in or not?
Yes.
Okay, I'm sorry, Judge. So you weren't under oath then. Did you, you represented to the court, though, that there's nothing specifically about lost profits in this agreement?
I've seen nothing in this agreement specifically regarding lost profits. It's not required. It's a question of law. And he's entitled to lost profit absent a waiver.
Objection.
Profits.
Objection. Non-responsive. I wasn't asking if it's a matter of law. I'm just asking if I was getting her to reaffirm what she's already said as a representation.
Sustained.
Okay, so now who is Robert Peterson?
He's an associate here at the firm.
Okay, did he start off working on this case?
I'm not sure I understand what you mean by that.
Have you reviewed the hours in your exhibit? I believe it's Exhibit 36.
I have.
Okay, is he down for some time?
Yes.
And do you remember what he did?
Well, yes, if you look at the affidavit, you'll see that he began drafting a trial exhibit list and preparation of a trial exhibit list. He performed an analysis of the client's documents, correspondence, and pleadings to establish claims and defenses at trial and for use as exhibits. He performed legal research on the affirmative defense raised by yourself of the enforceability of contingent contracts. He prepared a brief on that and corresponded regarding mediation and case deadlines.
Was this primarily handled at one point by Scott Colley?
Scott Colley did a lot of work on this file, yes.
And who is Scott Colley?
Scott Colley was an associate with the firm.
Did he do some work in preparing for trial?
No, he did not.
Okay. And when he left the firm, did Brian kind of pick up this case, or was there, am I misrepresenting what happened?
Brian actually spent very little time on this file, and really not until the last week or so has Brian been involved. Primarily when Scott left, I reassumed control of the file.
Okay. Before today, we really hadn't, other than some possible disqualification issue I talked to you about earlier, we had not ever spoken, had we?
Regarding this file or
This
ever?
file, this file.
I don't believe we have, no.
Okay. So Brian Benitez has been mostly the person that's interfaced with me in this case.
I don't know how much communication you had with Scott Colley, but it would have been Brian or Scott. I believe
Right.
you started off speaking to Scott.
Okay. And now getting to your testimony, what was the $8,000 for? I believe that was the first thing you talked about.
18,000. I'm sorry, 15,000.
Okay, let me change the question. Let me change the question.
Okay.
You gave different amounts, and I understand about what you said about some going to the Supreme Court or the Court of Appeals. Did you have tell me the major categories that you're testifying to as to post-trial testimony?
So $8,000 to defend at the trial level, $15,000 to defend at the appellate level, $18,000 and $28,000 to defend at the Supreme Court level against a cert or an actual accepted case.
Okay, so $15,000 for an appeal to defend an appellee's brief in the Court of Appeals, correct?
Yes.
Okay, and then $18,000 if there's an application for writ before the Supreme Court.
Yes.
Okay, and to defend that, and then additional $28,000 if the oral argument is ordered.
I included the 18 in the 28. So it would be an additional 10,000, not an additional.
Okay, that was okay. Now let's focus on the 8,000 to defend. You're saying after today, you're speculating that there would be additional 8,000 prior to entry of judgment?
No, what I'm saying is that if defendant were to appeal the court's ruling against her,
Right.
he had to defend that ruling at the trial court level. I anticipate $8,000 of legal fees to be incurred.
Okay, when you say defendant at the trial court level, you're speaking of a motion for new trial or a motion to modify judgment?
Yes.
Okay, you're not talking about an entry of judgment, defending an entry of judgment motion or making your own entry of judgment, are you?
Well, I'm talking about defending any sort of action brought to try to defeat a judgment granted in favor of plaintiff. I'm not saying that we would charge $8,000 to have the court sign a judgment in plaintiff's favor.
I think the testimony was up to and including mandamus, but we could certainly.
Okay, I'm not, excuse me, Mr. Benitez, I'm not asking.
I'm objecting that you're misstating the testimony, Mr. Clark.
Well, okay, but that's not what it sounded like. It sounded like you're
Overruled.
So the 8,000 is primarily for motion for new trial. Is that what you're saying?
That's not what I said, no.
Okay. You're saying anything from today on, you're asking for the court to award an additional 8,000. If there's like a alternative judgment put in, or tell me what the minimal, what would trigger that 8,000 being considered as part of the judgment.
Motion for new trial, motion to set aside judgment, any sort of motion that would seek to defeat a judgment in favor of our client.
Well, that last statement, it can be is pretty. What does that not include?
It would not include if you wanted to submit an alternative proposed judgment for the court's consideration.
And is there anything in the motion, in the rules of civil procedure that allow for an alternative in the trial level? In other words, if the judge issues a judgment, that's what the
Mr. Clark, let me just say this. If I award appellate fees, I'm going to award the attorney's fees plus appeal to the Court of Appeals and to the appeal to the Supreme Court. The other fees I'm not going to award, so you don't need to ask questions about them.
Okay, Judge. Okay, that's I'll pass the witness.
No further questions for the witness, Judge.
So plaintiff's arrest?
Plaintiff's arrest and essentially be excused from the stand, please.
Yes. Defendants, call your first witness.
Yes. I will at this point rest.
Okay. All right. I just have a couple of questions before I render verdict in this case. I'm going to go ahead and rule in favor of the plaintiff. I did have a question about one of the couple of the numbers here. First off, the amount I believe that you're requesting is $19,246.73. Is that right?
May I pull up the demonstrative aid?
Yeah, you don't have to. Can you just?
Okay, sure.
You can if you want. Is that the amount?
Well, it's $17,984.16. It's $15,969.13 for the work that was performed and unpaid. It's $2,015.03 for lost profits.
So $15,107.16 is the amount you're asking for what was unpaid.
$15,969.13 for the unpaid roofing work.
Okay, I'm going to award $15,969.13. I'm going to award attorney's fees in the amount of $15,895, appellate fees in the amount of $10,000 for appeal to the Court of Appeals, and $10,000 to the Supreme Court. All right. Anything else, guys?
No, Your Honor.
Not for plaintiff, Judge.
If you could go ahead
Judge,
and prepare.
that will not. I know the judgment's going to be prepared. There, I believe there was no evidence on this. May save us a lot of time. There was no evidence about any kind of lien or foreclosing of a lien. I didn't hear any evidence about that.
There was never a cause of action, Judge, for foreclosure of the lien. That whole line of thought was irrelevant.
That's correct.
I want to try it by consent, Judge.
Okay. All right. Prepare a judgment, Mr. Benitez, and make sure it says at the beginning of the judgment that this trial was heard on November 30th, 2021. Share it with Mr. Clark. Go ahead and then after it's been shared with Mr. Clark, go ahead and e-file it with the court, as well as emailing Rhonda. You guys have a great day, and I wish you the very best of luck, Ms. Raymond.